Welcome, everyone, to another edition of the SERMAPod. This is the podcast for the Sports and Entertainment Risk Management Alliance. I'm the host, CEO and founder of the organization, Rich Lenkov. I'm very pleased to have with us two of the most esteemed experts in this area of law. First, we've got Peter Ginsberg from Moskowitz and Book. We've also got Craig Seebald from Vinson and Elkins. He's co-head of the litigation and regulatory department. Peter, Craig, welcome to the podcast.
Thank you.
Thanks for having us.
So in the news lately, especially earlier this month, has been the PGA versus LIV litigation. PGA won the first round when a judge in San Jose ruled in favor of the tour. Peter, do you want to tell us a little bit more about this lawsuit and bring us up to speed up until Judge Freeman's decision earlier in August?
Sure. The driving theme or theory of the case is that the PGA exercised its monopolistic, anti-competitive authority to keep a group of golfers who wanted to join a competitor LIV Tour from engaging in tournaments that they deemed necessary to qualify for the end of the year playoffs. The theory was that the PGA, either through pure control of the market or through conspiratorial activity, suspended and banned those players without justification. 3 of the players moved for a restraining order, trying to obtain an order from the judge that would have allowed them to play in the first of the FedEx tournaments, and they were unsuccessful in that effort.
Craig, what did Judge Freeman tell us about at least the initial ruling? What did that tell us about the merits of this lawsuit? She went to some trouble to say that her ruling doesn't explain the underlying lawsuit, deciding whether, in fact, there is a monopoly of play. But she did give us some hint of how that might go down the road. Talk to us a little bit about what we learned from Judge Freeman's order.
Yeah, it was really interesting. She ruled from the bench, and then she issued an order a day later. So it was, as you say, we were very much, I guess to use golf analogy, on the first hole. They were asking for preliminary relief. They were asking for a temporary restraining order, asking them, as Peter was saying, to be able to play both in the PGA Tour and in the LIV Golf tournaments. Her ruling was really focused on one of the elements you have to show in one of these preliminary motions, which is irreparable harm. And she said, boy, I just don't see a lot of irreparable harm here, because you're telling me, okay, you're not going to be able to play in the PGA playoffs, but you can still play on the LIV Tour, you can still play in majors, you still have other opportunities to play. You're not being completely shut out. And oh, by the way, and I think this is really important, you have been compensated for this potential loss. You got paid big signing fees by LIV to induce you to move from the PGA Tour to LIV. So you've already been, in some sense, compensated. So you really haven't had irreparable harm. Actually, kind of benefited from this a little bit through this big paycheck you got to join the LIV Tour. As part of the preliminary relief, not only had to show irreparable harm, but they also had to show a substantial likelihood of success on the merits, which is what caused the judge, as you said, to get into the merits. She said a number of things, but let me just pause on one thing that I think is interesting that is always part of antitrust cases. And it's, normally, and Peter knows this very well too, normally you want to have plaintiffs that have lots of harm, they're about ready to go out of business, they're out of business. And here, the plaintiff's own expert talked about LIV already having gotten 20% market share in the last 5 or 6 months of existing. So she was saying, boy, I'm looking at these antitrust claims, and the fact that LIV is succeeding, they're throwing golf tournaments, They've gotten great players like Phil Mickelson, Dustin Johnson to come over. They're hosting on beautiful courses. They have a network of people working with them to have golf tournaments. So their very success, she's hinting, is undercutting their antitrust claims because, like she said, in 6 months, you've already admitted through your own expert that you've got 20% market share. That's pretty good.
Yeah, Peter, pick up on that. It's a great point, Craig. And Peter, if you can't pick up on that and how relevant that is, not only to this ruling, but how that'll play out in the future. I mean, it's again, there's lots of money involved here, and as Craig said, as the judge intimated, they're doing pretty well so far.
LIV is doing pretty well so far. I think this case is a toss-up. I think that each side has very strong and very weak positions. On the PGA side, it's clear that there is a core group of players that are protective of the tour. And I think that will ultimately benefit the PGA's argument that its membership rules are necessary in order to protect the product and not exclusionary, because no one had to sort of drop out. That was done by choice. I think on the other hand, every time Monahan argues that the tour is there for the players and he's there for the players, he loses an awful lot of credibility. The PGA wields an enormous power in the marketplace. On the LIV side, there is a sort of an attractiveness to saying, hey, look, usually the PGA gives, or at least considers in good faith, waivers so we can play in other non-PGA tournaments in here in order to protect its product. The PGA didn't give us that accommodation. But on the other hand, as Craig was saying, the LIV success is, at least so far, hoisting itself on its own petard. It's working against LIV by saying, we're getting great players, we're getting a good piece of the market, we're succeeding. And there hasn't been, at least so far, any evidence that the PGA is conspiring with the majors or media outlets. So there's an awful lot at play, and I think it's a close case. It's going to be very interesting to see how it develops.
Peter, you've represented many high-profile athletes, including many golfers. Craig, you're an avid golfer yourself. LIV is different from the PGA, right? I mean, that's part of the attraction. That's part of the marketing. You get to play music, right? Rock music on the course. It's not as stiff as the PGA. It's not as traditional. There's 54 holes, I think, something like that. How much of those factors do you think will play into the decision as to whether the PGA is exercising a monopoly? In other words, are there enough differences for LIV to say, or for the PGA to say that we're not a monopoly, as evidenced by the differences inherent to both organizations?
Let me take a crack at that. I think it comes into play in an interesting way that's a sideshow, but I think it's going to be a key part of this case is the official World Golf Rankings. You have this organization that sets the golf rankings. It's controlled by the PGA Tour, but also every one of the entities that controls the majors. And that's some of the things I think they're looking at in terms of, do we grant official golf world rankings to these players? And you already saw, and I thought this was really pretty amazing. Tiger Woods gave a press conference before the British Open where he, I think, laid out some of the arguments that we're going to see. And it goes along the lines that you were saying. It's not really a competition. There's guaranteed money. Everybody shows up and gets money. It's only 54 holes. It's a bit of an exhibition. You have rock bands playing. You have a shotgun start. So it's not a tournament golf that we know what it is, like the PGA Tour. And so I think that's where you're going to see this plan. And if it gets to the point where the official World Golf Rankings say, we're not going to give points to these players because we don't really consider this real competitive golf, I think you're going to see maybe a new lawsuit or this lawsuit further expand to focus really on that issue. Because if you don't have those golf rankings, you can't play in the majors. And that's a big problem for these golfers.
Yeah, I think that's a really interesting point. Peter, we now have a trial date, right? January 8th, I think, 2024.
Right.
Federal court in San Jose. Seems like a while away. What do you make of that trial setting? I mean, maybe you could as someone who is a veteran of these kind of cases and litigating them all the time, quite famously, maybe you could walk our listeners and viewers through why this case is set for trial so far down the road. Obviously, lots of issues involved, high stakes litigation. That takes some time, but maybe you could explain a little bit to our.
Right. It does take some time. Let me point out before I get to that one other fascinating difference as far as competition. LIV doesn't have to make any money. LIV isn't really an enterprise the way we're used to. That gives LIV an enormous advantage and something that I think it will have to defend against, as it's claiming that it is somehow, or its players are somehow aggrieved. But to get to the point of trial, there's an awful lot of work to be done. There's a whole discovery process where the parties will fight over what documents have to be given to the other side and what documents don't. I think the last time I litigated against Skadden Arps and the PGA over those issues, it took us months just to come to an understanding as to the confidentiality agreement. You know, the 12 people from Skadden who come to every court appearance all had something to say. And that process takes an awful long time. And hopefully, this judge seems to be fairly proactive, and hopefully the judge won't countenance any kind of delay when it comes to that and any kind of sort of unnecessary dispute. But then after the documents are produced and reviewed, there's a whole other aspect of discovery with depositions, taking examinations under oath. And that, I'm sure that there will be dozens and dozens of depositions, not only the players, but Monahan and his lieutenants and the people who are controlling LIV and making the business decisions for LIV. And there's sure to be motion practice. You know, there's no doubt the PGA at some point will say, LIV can't possibly prove we're monopolistic or engaged in any antitrust activity, so we're going to move for summary judgment. And it may well be that LIV is going to make a similar motion. So it sounds like January 2024 is a long way away, but it's really not, and it'll keep an awful lot of lawyers and an awful lot of non-lawyers busy, and a lot of media people having a lot to talk about.
I think if I could just jump in there real quick, I think, Peter, I'd be curious to get your thoughts. I think the most interesting part of discovery is going to be on the conspiracy claims. What communications did the PGA Tour have, Monahan, his staff, have with the major organizations, the Masters, the PGA, the Royal and Ancient, about whether they're going to stand with the PGA Tour or not stand with the tour? And whether there were winks and nods and agreements to say, boy, it'd be really helpful, PGA, if you didn't let these guys play in the Ryder Cup, that would really put the screws on them to come around and stick with us. And what do they say in response? I think that's going to be interesting. And like I said, I think the official World Golf Rankings is going to be interesting. What kind of discussions are they having in those meetings where they're talking about the membership and the ability of these guys to get official golf rankings? I think that's going to be really delicious discovery.
No, I think that's exactly right. The conspiracy issues are going to be, the most interesting.
So to that point, I want to talk a little bit about, because what really interests me, and I think a lot of our listeners who don't practice this kind of law all the time, antitrust law, from a very basic perspective, you talked about malice, and you talk about intent in these kind of cases. Look, the fact is that there are seemingly monopolies in sports, right? I mean, there are leagues that spring up all the time. The XFL, professional football, the XFL, the USFL, the AA, whatever that alphabet soup was a couple of years ago, the AF, and they inevitably fail, right? So is that purposeful by the leagues, by the dominant leagues, by the NFL, by the PGA? Are they conspiring to put down these other leagues, or is it the nature of things? Are these other leagues not succeeding just because that's the free market. And the free market dictates that because the NFL, because the PGA, whatever other league, has the product that consumers want, in other words, great quality play, star players, well-recognized brands, that's what's leading to this monopoly. That's a really nature or nurture question maybe, but that's what a lot of this comes down to, I think, right?
Yeah, look, I think that the driving force theoretically in enforcing the antitrust laws is what is best for the consumer. And it may just well be that having all the best football players playing in the NFL or all the best golfers competing in the same organization is best for the consumer. In terms of whether it's purposeful or accidental, there's no doubt it's purposeful. With a certain amount of sophistication, it may not be violative of the antitrust laws, but there's no doubt that each of the leagues and each of the organizations have ways to protect their turf and make its product appear, at least, to be more valuable by essentially having less competition. And I think it's an interesting question. Do people who watch golf, are they better off having everyone within the confines of the PGA, or are they better off having this sort of knockoff tour run by the Saudis? And I don't know that, I don't watch much golf myself anyhow, so I'm probably the last person who can answer that question.
Yeah, I don't watch much golf, but Craig, Peter raises a really good point, and isn't it what you want from a free market system that leagues do protect their turf, that they do want to, provide the best product to the detriment of competitors because that results in the best product for consumers? Does that mean that that's the requisite intent to establish monopolistic practice?
I think if you bring it back to the golf, I think there's a good question about whether these rules, are they really there just to protect the tour and its product? I thought they made a pretty good point in the oral argument where they were saying, look, we're having the FedEx Cup, which is going on right now, which is the golf playoffs. It's funny, the lawyer for the players talked about it being the Super Bowl. I'm not sure it's quite the Super Bowl of golf, but it's the playoffs that the FedEx Cup has. And if you're FedEx, what do you want? You want the stars playing. You want the PGA to have their players. So those rules actually benefit FedEx. It benefits me. I want to watch really good players play at these tournaments. So I think the tour is going to say, look, it's really these rules are there really to make sure that we have the best product for our audience and for our sponsors. And I thought they made a really good point, which was when the judge was thinking about the potential relief, the tour said, so if you let them play, what do we do when they show up with their LIV shirts on? What do we do when they have press conferences and start talking about how great LIV is during a PGA tournament where we have the contract for the TV rights? It's our sponsor. That just doesn't seem fair in America that you get to have competitors come into our tournaments and wear their shirts and do all those things. I think that was tough for the judge, and it wasn't really part of her opinion, but she started thinking about, I just don't want to be regulating what people are wearing at the tournament. I don't want to regulate what people can say and not say at the tournament. That doesn't seem right as well. So it's just how you look at these now. I'm sure from the LIV players' perspective, they say, hey, you keep calling us independent contractors. How are we independent under these rules? Independent means we get to decide. We can play the PGA Tour one week. We could play LIV the next week. We could play the European Tour. And we're not very independent because we can't make those decisions. Ultimately, it's going to be the jury that gets to decide which view of this world it is.
I'm glad you mentioned the jury. I'm a jury trial litigator. You both are. Juries are interesting people, right? All of this legal discussion does not always resonate with the average viewer or a juror, especially those who are sports fans, right? To our earlier discussion, people want to watch sports. They want to enjoy it. They want to get away from their everyday lives and the stresses of paying bills. They don't really care, I would, put forth necessarily about a lot of this, right? From a lot of the perspective of the average viewer or sports fan or just layperson, it's like, these are rich people arguing about a lot of money, right? And especially a lot of rich white people. You know, golf is predominantly white. There's been some noted exceptions, but very white sports. Does the jury care about any of this? Will people just chalk this up to lots of rich people trying to make more money? And I've got a second part I want to ask Peter, but let's tackle that question for a second. Peter, how do you think, I mean, we know this has got a lot of attention. People are buzzing about it all the time. What do you think the perception is out there in the potential jury pool about this issue?
Well, you know, I think that Craig made an excellent point. Or I'm sorry, Rich, it may have been you. This is a group, for the most part, of rich, white, conservative guys making a huge amount of money. So I'm not sure if the public really cares. There's also another group of golfers who I guess care. I'm interested to know what happens if some of the PGA players do turn this into a political battle as well. You know, some of the golfers start wearing "Remember Khashoggi" hats, and we don't want the Saudis and the people the Saudis have bought to be intruding into our tournament and causing tension and maybe more. I mean, I think that we're a long way off from knowing how this case is really going to develop. But I think generally speaking, juries care about whatever it is that is in front of him or her. And I have a lot of faith in juries and juries' ability to take their job seriously.
I agree, 100%. Craig, I want to turn to you because Peter raises a great point. You can't discuss this lawsuit without talking about the external factors, right? Primarily the fact that LIV is underfunded by, the Saudis, and that has raised the ire of many, especially and very loudly the surviving members of victims of 9/11, right? I mean, Donald Trump held a LIV event at his Bedminster Golf Club, and very prominent were families of 9/11 victims shaming him. We're talking in SERMA a lot about the issue of reputational risk, right? Not just risks involving injuries and, active shooters and people falling in stadiums, but reputational risk. In fact, I'll give a plug to a big presentation we have coming in March 2023 in Colorado, where we're dealing with reputational risk. How much do you think that's a factor here? And how much do you think that'll potentially drive the parties to resolve the issue before trial? It seems like we're going to trial on this issue, but reputational risk and the politics involved are inextricably linked with this lawsuit.
Yeah, from a pure antitrust perspective, these issues shouldn't really come to play. You're really looking at the competitive issues rather than these outside issues. But I don't see how these outside issues don't come into play. The jury is going to know about it. They have some effect. You can see just the back and forth between LIV and the PGA Tour, where LIV is pointing out all the PGA Tour sponsors that do business in Saudi Arabia and the players doing business in Saudi Arabia. So there's been this Twitter battle between who is more tied to Saudi Arabia than the other. And, that has to get through to potentially the jury and to the judge. That you just can't go through any of your day without seeing any of that information out there.
Yeah, Peter, I agree wholeheartedly. Peter, we talked earlier about, some of the golfers, and you've represented very prominently some of these professional golfers involved here, and also, some other very prominent high-profile members of the sports community. Les Miles comes to mind, Ray Rice. I've asked other people who have represented high-profile clients before. We had Alan Dershowitz on another podcast recently, and I'm always curious. It's hard enough representing clients, right? We all know that. We all represent clients. What are the added dynamics involved in representing high-profile clients, like athletes especially? What are the additional stresses, factors involved, like in this case, representing very high-profile athletes in a very high-profile case? What else goes into it as an attorney?
Well, most of the situations I've gotten myself involved with are when involve an athlete or a coach being in the spotlight and accused of some sort of horrific transgression, either rightfully or wrongly, and trying to figure out how to, remedy the situation. So this is a little different. The worst that can be said so far, at least, is that the LIV players have grabbed the money and are now complaining about it. That's a lot different than, for instance, when I represented Vijay Singh and Vinson, had a series of extraordinarily inappropriate, inaccurate, and offensive press conferences attacking Vijay and his character over something that turned out the PGA was just flat out wrong. Vijay was accused of using some sort of substance that would enhance his performance, and it turns out it was a substance the PGA was allowing the champion golfers to play, that it was clearly a placebo, that Vinson's people knew the players were using it. But the real emotional turmoil that Vijay went through for really a couple of years until we got to the point where we could resolve the case in a way that made Vijay feel like the fight was well worth it. But it's each athlete takes it differently. I represented Patrick Reed for several years, and he went through, as you all know follow golf, a series of very high-profile accusations, and he and his family took it very, very personally. I've represented other athletes and other coaches who are more detached and sort of more faith that ultimately the system will work. So it's really hard to generalize, but I don't think anyone ever comes out of these things the same as they were when they went into them, including
last
the lawyers.
question. Yeah, interesting, very interesting. Craig, last question goes to you. What, if anything, do you think this says about sort of the bigger picture, future of sports, right? I mean, there's lots of money, even before LIV got involved with sports, billions and billions of dollars. But, it's kind of a different level when you talk about the Saudis in some respects. They really have almost unlimited funds. Do we see this playing out in other sports, right? Will we see a competitor to other leagues? Will we see this in tennis, for example? What are your thoughts on broader implications with the amount of money and the issues we're seeing in this case?
Yeah, I think we're going to see this not going to be limited to PGA Tour. It's, the Saudis want to be, the term is sports washing, right? They want to be associated with the Phil Mickelsons of the world and potentially other sports stars. It's what they want to do. They have an unlimited budget to do that. And I think that's going to be a challenge for other leagues, other businesses, other industries as the Saudis do that. Like you said, they have just an unbelievable budget and are able to invest, to take their time. They're not looking necessarily to make a profit. They have other things that they want to do. And so I think that puts the onus on other leagues to think about how to react. I think you can say with the PGA Tour, maybe they didn't anticipate how much of an impact they were going to be. They've been fairly reactive. As you saw, even today, the PGA Tour came out with a program where they're going to offer another $100 million of money next year. They've made a commitment that everybody playing on the tour is going to get $500,000 guaranteed, no matter where they finish. And then if you miss a cut, if you're not one of the top 125, if you miss a cut, you're going to get paid $5,000. Used to be if you get cut, you got no money. And so I think some people might say, man, that would have been really helpful if PGA Tour thought about this, did that a year ago rather than now. I think it's going to be beneficial now. But I think as other tours look, they're going to have to look and say, what kind of lessons learned do we have? I think one positive, I think that other ones will say is that the PGA Tour took a pretty tough policy on its rules, which led to this antitrust case. But I just think that they couldn't have said, gee, we're going to grant waivers and everybody can go play the LIV Tour. I mean, I think that would have ended the PGA Tour. So I think people look back and say, I think they did some right things in terms of enforcing the rules the way they did. But I think there's going to be lots of lessons learned by other leagues because I think the PGA Tour is really the guinea pig.
And maybe the improvements show that competition really does have beneficial effect.
Yeah, the players have really benefited both on LIV and the PGA Tour. A lot of money has just come about in 2022 somewhere.
And Craig, who knows? Work on that swing, and maybe it's not too late to partake in.
I have a lot of work to do. Thank you.
I want to thank Peter Ginsberg, Moskowitz, and Book, and Craig Seebald of Vinson and Elkins for their incredible insight on this issue. We'll be continuing to follow this at SERMA and on the SERMAPod, and we'll ask Peter and Craig to come back and update us as this case evolves.
Sure.
Gentlemen, thank you so much for joining us. We really appreciate it.
Thank you very much.
Thank you.
Ideas, strategies, and opinions represented on this podcast are those of the speakers and do not represent the ideas, strategies, and opinions of their employers.